All right. Hello, everyone, and welcome to another live recording of the Financially Legal podcast, where we deal with all things at the intersection of finance and the business of law. My name is Emery Wager. I'm one of the co founders of Confido Legal, an embedded finance and payment platform specifically designed for the legal market. Today, I'm incredibly excited to welcome Evan Meyerson to the podcast. We're going to be talking about legal finance, and we're going to be starting at the 101 level and then getting a little bit more in depth as we progress. Evan will talk a little bit more about legal finance, but to me personally, a really fascinating, unique financing vehicle that's relatively new in the past decade or two. So really excited to dive in to learn. And Evan has a really interesting background. He's been a litigator, he's been in venture capital, and now at Burford Capital. So I'm going to start just give him a chance to talk about his background, talk about where he got to today, and then we'll dive in deeper from there. So Evan, thank you so much for joining, and tell us a little bit about your journey.
Yeah, my pleasure. And thank you again for having us on, Emery. We appreciate it. So I've been at Burford since early 2019. I joined from Paul Weiss, where I was a litigation associate practicing in their general litigation department. As you alluded to, I actually started my career out of college at Bain Capital in their venture capital fund, but made the fateful decision to go to law school, unlike a lot of colleagues who chose to go to business school instead. And I started after law school at Sullivan and Cromwell, then I clerked for a judge in DC. And instead of going back to S&C, I went to Paul Weiss. And about 6 years after law school, I found myself missing a little bit of what I did for law school. And that is being part of more of an entrepreneurial environment, more of a risk-taking environment. And, in many ways, that is the antithesis of what you're taught to do as a litigation associate in particular, right? Your goal is to reduce risk for your clients, not to take on more risk. And at this time, when I was thinking about what might be next for me, the idea of litigation finance frankly fell out of the sky. As I've come to learn being on the other side of things, litigation finance is not always front of mind for practicing lawyers, and especially big, profitable, hourly bill-based law firms like Paul Weiss. So when this appeared on the horizon for me, frankly, it was the first time I'd ever heard of litigation finance generally. Paul Weiss is not a big user of it. What I loved about the idea was it could meld the things that I really loved about being in venture capital, thinking about ways to deploy capital to benefit our investors and benefit the companies we're investing in, with the things I loved about practicing law, which was the strategy of prosecuting litigation claims, evaluating whether they are good or bad, coming up with creative arguments to advocate for your side, while maybe not so much doing the things that were challenging about practicing law, like massive discovery and, fill in the blanks, things that make being a litigation associate at hard charging law firms challenging. And I was lucky enough to land an offer with Burford, who I think we're going to talk about in a second, but the rest is history for me. I've been here for 5.5 years, coming on 6. And now I run Burford's US commercial investment platform here in New York.
Awesome. Well, it's an interesting journey and certainly a perfect background to talk to our listeners who are mostly attorneys about legal finance. So let's, as sort of promised, let's start as kind of the 101 level and just give an overview of what is legal finance or litigation funding.
Sure. So at the highest possible level, litigation funding is the provision of capital to support an ongoing legal claim or monetize legal assets. The way I would think about it is consider the investment strategies you're most familiar with, right? Like one can go into the public markets and buy stock. Someone can provide capital to a private business. You can put out a loan to a company that, has slow going cash flows, or an individual who wants to buy a house, right? Like all of these are well-known asset classes that have investments behind them. we're investors in an asset class too. And that asset class is legal claims. And the most typical way we invest in these legal claims is to provide capital during the active pursuit of litigation. And that capital would then be used to support a legal budget or a collection of legal budgets. So I think we're going to talk about portfolios later. But again, in its most basic form, and we'll talk about some other forms it takes, it's looking outside your own coffers, or if you're a law firm, taking something on a full contingency, finding ways to mitigate some of your risk for something that's going to probably take a long time, as litigation often does, by turning to a third-party investor like Burford to provide capital along the way. And in exchange for that provision of capital, we seek a return only from successful outcomes in your litigation. The value proposition is largely based on what we call the non-recourse component to what we do. We are recourse solely to a successful result in your litigation. You take our money, and if you lose, you have no obligation to repay Burford or funders like Burford. If you win, we'll share in the upside of what you've won based on the amount of money we've actually given.
Yeah, it's incredibly interesting. The kind of the non-recourse aspect of it. You can see how there's quite a bit of risk that you're taking in this proposition, given that, if they lose, nothing's recovered. You get nothing, right?
That's right. And look, our capital is priced for the risk. Well, we're not talking about bank loans, right? We're talking about capital that can often, end up being multiples of what we put out at the end. And the reason that it is priced the way it is exactly what you pointed out, which is, it is non-recourse. The value to both corporates and individuals who might take this to help pay for legal fees, or the law firms who take it to help mitigate some of the risk they're taking as contingency lawyers, is that, litigation can both take a long time, litigation can be expensive, and using outside money instead of your own to pursue meritorious claims, because obviously we're not going to fund something if we don't think there's a good chance it'll win, right? Because of that non-recourse component. If you lose, you keep everything. So it's very much not in our interest to deal with capital that, putting out capital for instances where we won't see a return on it. But the value is basically smoothing out or using as an alternative our money instead of yours. And, I think there is oftentimes a sense that, this only makes sense in a scenario where it's David versus Goliath. It's either a law firm that's strapped for cash or a client that's strapped for cash, and they have no choice but to turn to an outside investment provider and use their money instead. And that's true in some instances, but actually the majority of investments we'd make, I'd say, are with sophisticated commercial actors, both clients and law firms, because the two users of our capital are typically the law firm's client or the law firm, but sophisticated commercial actors who have made a decision where they think using our money along the course of litigation, or our money we should talk about monetizing claims, which is something else Burford does, will help them in the short and medium term while still maintaining a bulk of the upside if things go well, in a way that taking full risk themselves just makes less sense for the company and for the law firm. And so we are often working with people who are making an intelligent choice rather than a desperate choice to work with Burford. And that's been a really nice evolution for our business.
So just to be clear, this it can be used both by a law firm. You can lend to a law firm and directly to typically a plaintiff. Is that correct?
That's exactly right. We wouldn't really think about it as a loan just because of that non-recourse element.
Right.
But yes, in the vast majority of instances, there are two possible counterparties to a deal with Burford. One is a law firm and one is a client. And in both instances, like I said, the most typical version of a deal will be funding fees and expenses, either for a client to turn around and pay to its law firm, or to a law firm that otherwise has this on a full contingency, but wants to mitigate some of that risk by taking off the board some of the fees that it would have otherwise charged a client, wasn't on contingency. Or, especially in the last 5 years or so, another product that we have been pushing out into the market at a pretty healthy clip is what we call monetization solutions. Those can be for either clients or law firms. What that is a check written all at once or over time backed by litigation claims. So still the only asset that we're investing behind are legal assets, but that money can be used by a client or law firm as they wish. It's not tied to payments associated with specific litigation. Instead, particularly in instances where a claim is pretty far progressed, or there are reasons to think there's a higher likelihood of success than you might think for one just starting out, Burford is more and more investing in companies and law firms and writing checks for tens of millions of dollars that are backed by the future success of legal claims, but not tied to spend on those legal claims. And the value of that is if you're a company looking to make numbers for year end or use capital you can receive for affirmative litigation to help smooth out budgets defending defense side litigation or
Mhm.
pursue big projects totally unrelated to your legal department in a company, using a legal claim as an asset in the same way you might take out a loan using real estate or office equipment or future cash flows. It basically creates corporate finance for law. And that is a big part of Burford's growth over the last couple of years. And it applies to law firms too.
Mhm.
Of going to Citibank and taking out a loan with personal guarantees on partner homes and everything else. They can use existing books of business, so books of litigation claims, where that firm might have a contingency fee
Mhm.
and take out either, get a one-time check from Burford or money over time to smooth out the pace at which would otherwise be low, pretty slow and lumpy to see litigation results. Instead, seeing money from Burford at a smoother clip in exchange for a share of the upside in those cases.
Mhm. Interesting. But you're still getting paid back on the eventual outcome of the asset in this case,
That's
the
right.
litigation.
That's right.
Interesting. Tell us a little bit about how this may or may not impact the kind of the attorney-client relationship. And maybe you could also talk a little bit about some of the kind of the controversy around this, some of the drive for kind of greater transparency into who's funding what, cases and things like that.
Yeah, absolutely. So at baseline, Burford is a passive investor. We leave both strategy and decision making to the client in consultation with their lawyer in virtually all instances. What Burford offers is to be a source of information and experience that clients and law firms can avail themselves of if they so choose. Obviously, Burford in particular has the largest pure play portfolio in the legal finance industry. We have a database that covers the most resolved funded matters around the world, and we can leverage that experience and data to help provide thoughts on how long this will take to resolve, how it might settle, how to think about settlement, what lawyers are best suited for a given litigation. We can provide that advice to clients. We don't charge hourly for it, which is nice. But at the end of the day, we structure and price our deals to ensure as best we can that incentives are aligned, that the recipient of our capital, their incentives are aligned with ours, because we know and accept that at the end of the day, decision making lies with them, not us. There has obviously been a lot of noise around disclosure of litigation finance, question raised about who really is the party in interest, who has decision making power. And those questions are typically raised by the Chamber of Commerce, who obviously has an agenda, a dog in this fight, which is for a long time, large corporate entities maintained a significant competitive advantage when it came to litigation because they were super well funded and the people suing them, or often the companies suing them, were not. And to suddenly see an evening of that playing field over the last decade with litigation finance means that for meritorious legal claims against big companies, those pursuing them actually have the resources to do it. And that has been scary, I think, to some of the members of the Chamber of Commerce. The great irony, of course, is that as Burford has grown and as funders like Burford have grown over the last years, over the last 5 years, in particular, some of the most significant users of litigation finance have been the Fortune 500 companies that used to sign the letters for the Chamber of Commerce. And so I think Burford's view generally is we're certainly not against disclosure categorically. We're against disclosure in the wrong way for the wrong motive. We don't want to be in a situation where disclosure is meant to distract from litigation and create challenges for otherwise meritorious claims just to continue to give a competitive advantage to well-resourced but bad acting defendants. And so we just want to make sure that everyone's motives are as pure as they can be when thinking about disclosure, but certainly within the confines of our own deals, for instance, we always recommend that the lawyer, if we're doing a deal with a law firm, we always recommend that the law firm disclose the presence of litigation funding to its client, right? Like the last thing we want to do is for anyone to be surprised. But what we don't think is the right way to go about this is be in a world where litigation funding is used strategically as a force for distraction, as a way to actually add expense to litigation through fishing expeditions in discovery, and as a way to sort of paint this picture of scary outside malfeasance in an attempt to distract from the actual wrongdoing that led to the litigation in the first place. So that's where we are.
Yep. Avoiding the situation where a foreign government is funding non-meritorious claims potentially to, like you said, distract as opposed to actually let meritorious litigation proceed.
Yeah. I mean, frankly, it doesn't seem like a very good business model to fund non-meritorious litigation, but it certainly doesn't stop people from trying to do a little fear mongering.
Yeah. But let's talk a little bit about you alluded to kind of the portfolio method versus, an individual claim. Talk a little bit about the difference there.
Sure. So, we talked about the two most common recipients of litigation funding, that's the law firm and the client. There are also two most common forms and structures our deals take. One is a single case opportunity and one is a portfolio. In a single case opportunity, the funding will go toward one piece of litigation. And the pricing for that deal will often be higher because our success is based on one outcome. Will that single piece of litigation resolve well, or will we lose all our money? And our pricing reflects that risk. Portfolio financing, both for law firms and for corporate entities, involves multiple legal claims. So for a law firm, that could be a book of contingency matters where to date they've not seen any money. And instead, what they'd like to do, again, like we talked about, was see some money over time so that they can pay their associates, keep the lights on, even though they're maintaining most of the upside for themselves if any of this litigation hits. And for corporates, more and more, we are seeing corporate entities get a little more sophisticated about affirmative litigation and the value of pursuing claims rather than leaving them on the table and not just using your legal budget to defend yourself. And a lot of these companies now have multiple litigation claims that either we can put into a portfolio to fund the fees and expenses for those claims as they go, or a portfolio that leads to a monetization deal where we're actually just writing a check, again, to that corporate entity using multiple legal claims as the collateral for that investment, but still only recourse to those legal claims and not recourse to anything else. And the pricing reflects that what we call cross-collateralized risk, meaning we're not reliant on one single binary outcome on one case, but rather everyone can go home happy if there are sufficient wins, even if there are some losses across a portfolio. And our pricing will reflect that reduction of risk.
Interesting. So our listeners span a variety of practice areas, a variety of firm sizes, and they deal with a variety of different types of clients. Can you talk about what's kind of the ideal case size for this, or any other attributes, practice areas, like what makes a good, what falls in the range for legal finance?
Yeah, well, the less satisfying answer is it depends what legal finance provider you're going to work with. Burford in particular operates at sort of the higher end of the market, in part because I think as victims of our own success, our capital pool is pretty substantial. And so to move the needle for Burford, these have to be larger, higher octane type claims. So speaking only for Burford, it's hard for us to do a deal where the need is much less than 5 million. It does not mean we have to deploy all that capital on day one, but it means that if your full legal budget is $1 million to get through trial, it's probably going to be a little small for Burford. And if you're thinking about it in the single case context, so not a portfolio, but the most simplified version of things, we typically think about a 10-to-1 ratio between the investment need and actual damages for a claim. So if your budget is 5 million and you're seeking outside help from Burford to fund that $5 million, it's hard to make the economics work if the claim isn't worth at least $50 million.
Mhm.
And again, there are exceptions to this. It's really a rule of thumb meant to think about earlier stage litigation claims, right? Like you've filed a complaint, but you haven't yet gotten past motion to dismiss, just gotten past motion to dismiss, right? Earlier stage. If you have a judgment that's $40 million, $30 million, come to Burford. We'll talk to you about it. But if you're starting out and your claim is for $50 million in actual damages, not including punitives, the reason for this 10-to-1 idea is most likely outcome in meritorious litigation is still settlement. And going back to the prior theme of making sure incentives are always aligned between us and our counterparties so that everyone makes the most commercially sound decision, we want to ensure that notwithstanding the pricing of our deals, given the risk that we are taking, there is enough room for the decision maker, who's not us, decide to settle and resolve litigation at the levels we think are most likely. And it's virtually always going to be a discount to your actual damages number to allow them to settle their claims in a way that provides Burford the return that its shareholders require while still keeping the recipient of our capital incentivized to say yes to that settlement. And 10-to-1 is just an easy way of getting to that math. But again, that's more a rule of thumb than a rule.
Yeah. Yeah. And I know there are companies out there who are going kind of on the smaller end, but is that I assume maybe the unit economics are similar, like that 10-to-1 might still apply even if it's, $1 million or.
Yeah, I would think so. And if you are a user of litigation finance, I would be wary of a situation where you're asking a funder for $2 million and you have a $14 million claim because, there is some market pricing for our product.
Mhm.
And you might be buying into a situation where you can't actually sell because you'll owe too much to the funder. And that's just a
Interesting.
bad situation to be in. So I think it may very well be the exact same rule of thumb for other funders, but in any event, it should be the rule of thumb for a user of litigation
Mm,
finance too, right? Like the last thing you want to do is price yourself out of a settlement by taking on litigation funding.
yeah. No, that makes sense. That's interesting.
And to be clear, I mean, even if $5 million is low end of what Burford can do, we've done deals in the many hundreds of millions of dollars as well. So it is a pretty wide range, and it's an exciting space to be in where you can sort of invest in that kind of range and scale. But, needs at the smallest end of the market are definitely harder for Burford at this stage.
Yeah. Yeah. And it'll be interesting to see how that changes in the future. And this leads into my next question for you with tools like AI coming into the space more. I can imagine the underwriting process, or especially, a portfolio, to be fairly involved, for you all. How do you see AI kind of changing litigation, legal finance in general, but also maybe talk a little bit about the underwriting process as well?
Yeah. The two places we're most excited to start developing AI solutions, and frankly, we already are with our origination effort and our underwriting. The more we can use technology and predictive coding to tell us who is going to be the most likely user of litigation finance, who would be a good target for Burford in what's a pretty expansive legal marketplace, especially in the US, but also abroad, the better and more targeted our business model can be. So we're certainly looking at uses of AI on the origination front. On the underwriting front, Burford uses probabilistic modeling in every one of our. So on its face, the probabilistic models we use, no one would call that driven by artificial intelligence today, but we are actively incorporating um, AI coding and AI principles into that effort to help especially leverage the data we already have about funded and resolved cases or funded and ongoing cases, given the size of Burford's platform, incorporating external data, which is most available for federal court cases today, but increasingly available for state court cases in the United States, and coming up with a much more refined and repeatable predictive model for litigation. As long as human beings are judges and human beings are lawyers, I would be pretty skeptical of argument that AI can just take over the decision-making process for litigation funding. What we do is bespoke and customizable and still difficult to predict to the, to an extent where AI is nowhere close to replacing me, thankfully.
Mhm.
But it certainly can be a tool that we leverage to get smarter about the decisions we make. And that's a huge ongoing effort for
Mhm.
Burford. Yeah.
Yeah, and it seems like the more decisions you make, you get such a great visibility into the outcome because it matters so much that over time, I can only imagine that's getting smarter and smarter. So,
Yeah, for sure.
perfect. Well, we're about time. I would love to. You have a project called the Equity Project, and we're not going to be able to do it justice in the minute we have left. But maybe you could just speak to that. Tell us a little bit about what's going on there.
Yeah. So Burford is now in the third iteration of the Equity Project, which is a pool of capital we committed, has grown over time, started with 50 million. We filled that up, 100 million, filled that up. And in September of 2024, committed another $150 million to funding opportunities where the lead lawyer is either female or racially diverse. Origination credit will go to a female or racially diverse lawyer. In-house counsel is female or racially diverse. And the idea is, despite all of the progress we've seen in the legal profession over the last decade, in terms of equaling the playing field for female and racially diverse lawyers, we're nowhere near where we ought to be. And while Burford has no illusions of equaling that playing field itself, our idea was by dedicating a pool of capital to cases where the case is being run by, or the other categories I mentioned, a female or racially diverse lawyer, that would incentivize our counterparties, both corporate and law firm, to, make the progress they ought to have made years ago in giving chances to those.
Mhm.
And so we've been thrilled with the success of the Equity Project, and frankly, thrilled with the speed with which we've been able to deploy that capital to the point where we've now raised set aside 3 of these Equity Project funds. And, we're happy to try to do our part to make sure the most qualified lawyers, regardless of their background or where they came from, are trying our cases. And it's something we're very proud of.
Awesome. Well, excited to follow the progress there and see where legal finance goes in the next couple of years and decades. Going to be really interesting. So, Evan, thank you so much for joining. I have a million more questions I'd love to ask, but I know we're at time. If our listeners are primarily law firms, if they're curious about using litigation funding, legal finance, what's the best way to get a hold of you and your team?
Yeah. Well, look, I'm on the website. Go to burfordcapital.com, look up Evan Meyerson. Contact me on LinkedIn if it's easier, whatever works. But we're always here to answer questions about how we work, what our solutions look like, and keep educating people in the marketplace. So always feel free to reach out.
Awesome. Well, thank you so much. This has been the live recording. We'll have the actual episode out here in a few weeks. But thank you all for joining. Evan, thanks again for coming.
Thanks, Emery.